pick up part three. And I think this will be a relatively sort of brief section because this is kind of a mishmash of some of the other key changes that are not necessarily, fitting into one topic or one theme, but as nonetheless significant changes that have happened in the Companies Act since it was brought into effect. So here, it's kind of useful to think about the changes that have taken place in a few buckets or categories. And this is something that I've just done for the ease of taking you through it. And obviously, this is not how these changes have actually been brought into effect. And secondly, like these changes have actually come into effect over a period of time, starting from 2015 until 2020. So again, this is just to give you a flavor, and it's definitely not exhaustive of all the changes that have actually taken place. So I think category one that is useful to talk about is changes or amendments which have just either expanded the scope of application or brought in clarifications as required to delineate or to explain or clarify exactly what are the what is the extent of application of that particular section. So, for example, the definition of associate company, if you are aware earlier, this referenced associate company was identified in terms of holding of a specific percentage of the share capital in such company. So if company X held a specific percentage of share capital in company Y would become an associate of company X. But what the amendment has done subsequently is to change the word total share capital to total voting rights. So this is may seem like a minor change, but actually these are just instances of the regulation keeping up with what may actually be already happening in practice. So even so, in our example, it is possible that company X holds say 40% in company Y, and therefore company Y would have been an associate of company X. But company Y has another shareholder, Z, who is a preference shareholder and whose preference shares have actually become voting, who is actually able to exercise, a significant proportion of voting on any matters relating to shareholders. So, for example, this could be, say, a 40% voting rights as actually belongs to Z. So, in this case, Y would be associate of Z as well. And I think that is one of the key changes that the definition of associate company and the implication of changing share capital to voting rights has brought into effect. Similarly, there were changes on clarifying aspects like the holding company could be a company. So a holding company is defined with respect to a subsidiary company. But it was important to clarify that a holding company could also be a body corporate, which means that it's not the case that a foreign company, which would not technically be a company under the Indian Companies Act, can never be a holding company. That is not the case. So this clarification was important to bring out that position clearly. Similarly, definition of KMPs, that is key managerial personnel. This is an area where there has in fact been a kind of expansion to say that board can identify any specific person to be a KMP to whom then certain obligations under the Companies Act apply, or anybody who directly reports to the board can also be identified as KMP. So I think again, just to give you a bit of background, I think it's important to say that in some cases the Companies Act is reducing its jurisdiction, and in some cases it seems to be expanding. So for a practitioners, I think it's interesting to see what are the areas where they are deciding to go more into compliance and increasing the scope of applicability versus areas where the legislature feels that these are aspects which can be left to the company or its shareholders, and where actually ease of doing business is more important consideration than regulation. So, with this thought in mind, I think we can pick up category two, which talks about the ease of doing business changes. Now, some of them may seem rather minor to you, but as a practitioner, I can tell you that this makes a big difference to the company's day-to-day operations. For example, removing the requirement of having a common seal. You know, legacy of the 1956 Act, and basically the requirement there is a common seal which is placed, and then there used to be a whole lot of legislations around where the common seal is placed and whose presence can it be actually applied to a document, etc. And all of this clearly added to the compliance burdens of the company, especially for example, in the case of a foreign subsidiary which actually perhaps just has one resident director and may not even have a lot of operations. Thankfully, the Companies Act has done away with this concept. I mean, if the company still has a common seal, of course, it can apply that, but there is no mandatory requirement to have such a common seal. Yeah. The other key change, which is fairly recent actually in the 2020 Act, is that initially the definition of listed company under the 2013 Act said it was any company whose securities had been listed. Yeah, so the definition of listed company very recently, they have amended this to clarify that there can be certain categories of companies whose securities are listed but who are exempted from being classified as a listed company. So yeah, I think I was on picking up on the definition of listed company. So again, just to give you the background on this, the listed company under Companies Act is defined as any company whose securities are listed on a stock exchange, and the compliance prescribed for a listed company is higher than those prescribed for a company which is not does not qualify as a listed company. So in terms of governance, disclosures, etc., um, a listed company has a higher compliance burden. Now, one of the implications of this definition was that private companies whose debt has been listed on, say, the NSE or BSE or otherwise, would get defined as a listed company and have to comply with this higher compliance burden under the Companies Act. Now, this was a peculiar situation because typically we recognize under company law jurisdiction that private companies are typically to be regulated by the company and its shareholders, and the government reporting and disclosures are supposed to be a lesser footing for private companies than they are for public companies or listed companies. So the latest amendment of Companies Act is finally, given into this long-standing industry demand of saying that listed companies would mean companies that have their securities listed, but it is possible that the central government may exempt certain categories of companies from being referred to as a listed company. And under this exemption and a subsequent rule, what has happened is that private companies whose only debt securities are listed under the SEBI regulations are no longer qualified as listed companies under the Companies Act. So again, just taking a step back, this is an example where the jurisdiction or the applicability of the Companies Act is shrinking, and it has been sort of narrowed down. In distinction to the other example we saw a few minutes ago, where they are trying to expand the scope. Next one, I think, and maybe I'm going to run through the remaining ones quite quickly. The next one talks about alignment of prospectus disclosures with SEBI. So in the initial version of the Companies Act, there were a lot of provisions dealing with what a public offer for securities, which is a red herring prospectus, what are the disclosures that they should contain. But actually, this is a field that is substantially governed and implemented by SEBI itself as part of its ICDR regulations, which is the issue of capital and disclosure regulations. So this was an example where the change was made just to align it with the other regulations and to ensure there is no duplication. Similarly, there was previously a requirement in the Companies Act to report significant changes in promoter holdings. But if you actually think about it, this is again a field which is substantially occupied and dealt with by SEBI in terms of its takeover regulations. So these were instances where the authorities recognized that there are other regulators or other subjects dealing with this, and there was no need to create a duplication under the Companies Act and increase the compliance burden of companies. Another few examples of procedural simplicities. Earlier, there was a concept of postal ballot. There were certain items which were, important decisions of the company, which could only be taken by means of a postal ballot. The thinking behind this requirement was really that it was felt that the present that requiring the shareholders to attend in person and vote would obviously result in a lower level of participation by shareholders. And a postal ballot, which is technically just actually that somebody mails you a notice and you get 30 days to respond with your decision on and vote on your shares, would allow a larger proportion of shareholders to participate in the decision making. So this is now when there was a requirement to have certain matters decided only by postal ballot. This typically meant that this was a very long drawn process, a lot of cost for the companies. They had to print the ballot, mail it to all of their shareholders, wait for the responses to come back. And usually the time taken to do a postal ballot process was on an average 30 to 35 days, was much longer than what you would do to hold a meeting, which is 21 days minimum notice. So the end result was that it was longer, more expensive, and perhaps more complicated for the company to get certain decisions taken by its shareholders. And in terms of the pro was obviously the better shareholder participation. But really now what the Companies Act has done is remove this said that a postal ballot can be given effect to by allowing e-voting on the same decision. So the objective of allowing greater shareholder participation that can be met by permitting electronic voting by shareholders, which obviously does not require them to come and be present in person at the physical meeting. So this is an example where changes are just being made to keep up with the changing technology and the way companies are operating in real life, and to make it easier for companies to comply with certain corporate governance requirements. Now, I think next two points are similar, allowing foreign subsidiaries to conduct its EGM outside India. Similarly, traditionally directors have been allowed to attend by video conference, but they were not counted for quorum. But now there is a provision that if those present in person, in physical presence, are sufficient to count for quorum, then the directors who attend by video conference will also be counted. So, okay. Moving on, I think other sort of just briefly touching on key areas. There have been significant changes in the private placement process, which is Section 42 of the Companies Act. So if you may recall, when the Companies Act came into effect, this was an area of significant update over the position under the 56 Act, where Section 42 required a private placement offer letter in a specific format called PAS4 to be created for each private placement. There were requirements to to obtain a valuation, to file these documents with the ROC, to maintain a register of offerees, and there was significant compliance and process related aspects in the private placement, which used to make private placement a pretty lengthy process, which is actually contrary to the intention. I mean, of course, shareholders should be informed and should be allowed to vote and agree to a private placement process. But the idea was always that a private placement is something that should be done relatively quickly to allow the companies to fundraise in a rapid manner. Subsequently, Companies Act is again having from 56 to 2013, they made it quite a detailed process. Yeah, so I was just mentioning that I think in 56 to 2013, the private placement process was made fairly detailed and heavy on disclosures, etc. But subsequently, there has been again an attempt, given feedback from the industry, etc., to roll back some of these complicated procedural requirements. So, for example, There is still a requirement to have a private placement offer letter, but that is no longer required to be filed with the ROC. And the disclosures therein have been streamlined, which makes it easier for the company to compile this document, and also allows the information to be kept confidential rather than being filed with the ROC, which is then a publicly available document. So this is an example of again a change where the compliance has been eased. Another substantive change that maybe very briefly we can touch on is that this was not really a change. I think that would be wrong to term it as a change, but the provisions of Companies Act 2013 always allowed for a restriction on the number of subsidiaries the companies could have. And subsequently, in 2017, the government has brought out rules which say that company X can only have a certain specific number of subsidiaries. So 2 layers of subsidiaries are allowed, and beyond that, if subsidiaries are not allowed. So in the sense, this is again an attempt to simplify complex holding structures to prevent cross holding and to ensure this clarity in corporate ownership and structuring, and to prevent sort of really detailed and complicated structures where you had entities holding 50% and X would hold 50 in Y, and Y would hold 50% in X, and all of these various examples were there in the industry. So this is one other key change that has happened. Again, a couple of sort of procedural aspects. Now, public companies can only issue and transfer shares in demat form. This is again something towards improving transparency and governance. The latest amendment to Companies Act has also allowed provisions or brought in provisions which could, set up the framework for the companies, for the MCA to uh, clarify that certain aspects of Companies Act apply or don't apply to companies, so that they are able to list directly abroad. This is an important step in getting to direct listing, which is more enabling because this is really driven by SEBI regulations. But MCA has made latest changes which sort of allow the framework to be set up to ensure that Companies Act requirements don't apply if for direct listing entities. And I think the last one that it's useful to talk about is on corporate social responsibility. Again, this is a sort of a key or an important plank of Companies Act in terms of how it has tried to use the regulation to promote corporate social spending, and it has made it mandatory. And this is really the change. Earlier, when 2013 Act was brought into effect, it was a comply or explain obligation. You either spend 2% or you explain why you were not able to spend 2%. But now it has become a mandatory obligation, and if you're not able to spend 2%, you are required to mandatorily transfer that to a certain fund, or keep it, or you can spend excess in future years and set that off against your obligation in a specific financial year. So this is an important step and does make a real effect for the corporates involved, because earlier, I mean, yeah, of course it was desirable, and I think a lot of the listed companies, etc., were actually spending the CSR. But the fact that it is now mandatory means that companies may as well figure out the projects and spending and take action to ensure that they are actually spending this 2% on various CSR projects. So really, I guess this change has given teeth to the provisions of CSR. And again, I think there are some changes which have been made to make it easier for companies to comply with the procedures, such as that they don't need to have independent committee in a independent directors in a CSR committee. So since CSR obligation can apply to private companies as well, the earlier requirement of having independent directors in the CSR committee did place considerable compliance burden on private companies. But now the government is making changes to make it easier for companies to comply with it, while at the same time making it mandatory to actually spend or contribute that 2% of profits towards CSR projects. So I think that's really where we're going to stop.